running between passport office and the police commissioner's office to find out the status of the passport application. So here he was not getting any, he was not being entertained in a proper manner. So the RTI application seeking information about the daily progress made on his application eventually gave him solace, and he immediately got his work done just merely on filing of the RTI application. I think you have another session now. In the end, there are different kinds of cases, many more that can be included here, or which have been the subject matter of the RTI Act. In the end, I would like to conclude: be informed, be aware, be confident, and be liberated. With these words, thank you all for your patient hearing.
Thank you so much, ma'am, for this wonderful session. Now I would like to open the floor for questions. Students can raise their hands. Okay, so thank you, ma'am, for this session. Now I would like to call upon.
Thank you so much.
Oh, we have a question.
Okay.
You can unmute yourself and ask the question.
Good morning, ma'am.
Very good morning.
Ma'am, as we all know that the RTI 2019 amendment was in a very controversial amendment, and it seems like they are revoking our fundamental rights. And Supreme Court is also seems like powerless because the central government is not responding to any plea from more than 1 year. So, ma'am, what is the solution for this, and how can we get to any conclusion on this?
Yes, recently also, there is one case recently where interpretation has been given by the Supreme Court with that regard, is that where there is no fee is to be charged for the kind of information. So here some information was asked from the Gujarat High Court, for which a procedure has been laid, and wherein some fee is charged for that. So the Supreme Court has taken the view that there is no inconsistency between the RTI Act and the provisions of the High Court, the rules and regulations of the High Court with that regard. And the Supreme Court has also not given a very positive response in that case, and it is also criticized. So anyway, whatever are the laws, whatever, this power has been given to us by this great legislation, which has opened up various horizons. And, we can see with the success stories that a good number of cases have been solved, and it has really empowered the citizens of the country. So eventually, if the government is trying to fiddle with the kind of empowerment that had initially been given by the legislation, I'm sure that the will of the people will certainly prevail, and eventually the government will have to give up to in whatever manner that is being curtailed. So we wish and hope that the Supreme Court intervenes and comes up with some proactive role being played by the judiciary in that regard.
Thank you so much, ma'am.
Next, we have Aryaman Singh. You can unmute yourself and ask the question.
A very good morning, ma'am. Am I audible?
Yes, absolutely.
Sorry in advance if I ask the trivial question. But I still have a doubt that how old question may be allowed to ask from the authority or can be sought under RTI Act. I mean, it can be possibility. There can be a possibility that the government, if I mean, the answer I seek from the time where the government was different or the public authority was different then. So, is it a possibility that I can still be answered by certain authorities?
See, generally what happens is, these are the practical problems basically. Generally what happens is that like the certain kinds of records that they are maintained throughout the years, but there are certain kinds of records which are not maintained, and it is only for certain period of time that they are to be, like, let me give you an example. Like in we keep the project reports of the students. It is a policy decision that we will be keeping the records of the project reports of the student just for 2 years. So obviously if after 2 years any information pertaining to them is asked for, so obviously we are not maintaining the record, so we cannot possibly give the information relating to them. So it is a huge problem. Now let us say we have seen that after 20 years, even those such kind of information which was otherwise exempted under section 8, if after 20 years, the lapse of 20 years, even that kind of information would be open, that kind of information would also be open, and no such would come out of that exemption of provided by section 8 of the RTI Act. In that case, if they are no more having the information, how would the information be given in that regard? So taking a cue from section 8, it very clearly mentions the lapse of 20 years. So that means as much the information which is as much 20 years old can certainly be asked in that regard, because it only mentions the span of 20 years, which allows the lapse of 20 years would probably give the information, would open up that information for the disclosure also. So that depends on what kind of information is sought and whether the records have been maintained by the concerned authority in respect of them, whether it was mandatory for them to maintain the records or not.
Thank you so much, ma'am.
And let me say that no question is futile. As you said in the beginning, for a trivial question, no question is trivial.
We have one more question. Student, you can unmute yourself and ask the question.
Good morning, ma'am.
Good
Am I audible?
Yes, please.
Ma'am, isn't Official Secret Act 1923 an obstacle to the implementation of RTI Act?
See, it is not that every kind of information, official secrets, as it the nomenclature of the act itself says Official Secrets Act. So that means there are certain things that needs to be kept confidential. And certainly the purpose, there obviously has a purpose and object behind the creation of any law. So if it is an Official Secrets Act, there are certain contentious matters which are covered under the Official Secrets Act. And I don't think that it can be considered to be an obstacle in that regard, because there are other kinds of information also which have been, covered under this, as I have given you the example of any information relating to the victim of rape, or for that matter, regarding the whistleblower. So if we start taking it as an obstacle to anybody's right to information, then in every case we cannot say so. Otherwise also, we have seen that there are other categories also. Whatever is important for the strategic or say for the safety of the country, that certainly has already been included under the exemption clause. So I don't think that it would be of any hindrance in that case.
Okay. Thank you so much, ma'am.
Thank you so much, ma'am, for this wonderful session. It was truly a pleasure to be a part of this session.
Thank you. Thank you so much once again. Due to paucity of time, I had to rush through. So anyway, thank you so much.
Students, the next session will be, guest will be joining us shortly. So please don't leave the session. We will be back in a short while. I would like to call upon Professor Dr. Ajay Ranga, National Law University, Shimla. Sir teaches criminal law, jurisprudence, right to information law, and law and justice in globalizing world and forensic science. Sir has presented 60 research papers in different international, national, and regional seminars. He has published 30 research papers in different research journals of national and international repute with high impact factor. It is an honor to have you with us today, sir, and I would like to request you to address the students.
Thank you, dear. Good morning, everybody. First of all, I would like to feel sorry for this technical delay. It is because of the technology. Sometimes it facilitates us, sometimes it creates trouble to us. And today was the time to face the trouble of new technology. Now we are coming over from this problem, and let's start with today's discussion. I have to talk about the Right to Information Law, RTI. May I know how much time I'm left with to discuss so that I will modify my discussion accordingly? Am I audible?
Yes, sir, you're audible.
So how much time I'm left with?
So there is no particular time, but you can continue as you like.
No time limit?
So around 30 minutes, I guess.
Okay, let's start with this discussion. I think this is visible to you. I have shared a photo. Is it visible?
Yes, sir, it is visible.
Okay. See, I will bifurcate my talk into few categories. First of all, I will talk about a very brief historical development of RTI law, how this RTI law came into India, and then what is the structure of RTI law. Then what are the information which can be provided and what are the information which cannot be provided, and who is competent or eligible person to seek information and who is not eligible to seek information, and then house will be open for your discussions. And in between, I will talk about how to write a proper RTI so that you can get information properly. So the first one, see, first of all, in the world, in the year 1776, Sweden was the country and you can see that today's International Transparency Index, the world, Sweden, Denmark, Norway, these are the corrupt countries in the world. From the last 5 years, Denmark is the least corrupt country in the world according to the Transparency Corruption Perception Index. Now, thereafter, the UN General Assembly passed a resolution in the year 1948 declaring freedom of December 1976. Recognizing the people's right to have access to official information, India was signatory to this movement. Thereafter, in India, the development relating the right to information law started in 1976. The first case was Raj Naran versus State of India. In this case, Honorable Supreme Court held that right to speech and expression, a right to know, right is a fundamental right of citizens under Article 9 of the Indian Constitution. Then the first political commitment to the citizens, right to information come up on the eve of Lok Sabha election in 1977. The Morarji Desai led Janata Party government 1977 in its election manifesto. Hello, am I audible?
Yes, sir, you're audible now.
Okay. I was talking about Morarji Desai's manifesto. The Morarji Desai Janata Party government in 1977 in its election manifesto promised an open government and declared that it would not be misuse the intelligence services and the government authority for personal and political gain. On the basis of this, the Morarji Desai government win the election with the majority, and thereafter he constituted a committee to look into the modification of the Official Secret Act 1923, because this is the act which is prohibiting to know what is there in official record. This is the law which is putting limitation on disclosure of information to the public. So first of all, they thought to amend this law, and he constituted the committee to look into the probabilities to amend this law. But unfortunately, this committee recommended no change, and this recommendation of no change by this committee closed down all the doors of the transparency and openness in the administration of the government. Thereafter, the Honorable Supreme Court in SP Gupta versus President of India in the year 1982, Supreme Court again declared the disclosure of information in regard to the functioning of government must be the rule and secrecy an exception. Thereafter, another important case, that is Mr. Kulwal Singh, Kulwal versus Jaipur Municipal Corporation in the year 1986, Supreme Court gave clear-cut directive that the freedom of speech and expression provided under Article 19 of the Indian Constitution clearly implies a right to information, as without information, the freedom of speech and expression cannot be fully used by the citizens. And if they want to use this freedom, then this freedom to information or freedom to know must be, right to freedom to know must be given to them. So this was the national and the judicial pressure on the government of India to pass this RTI law. In addition to this law, the government of India was facing different kind of agitation by different people, different social organizations You might have heard about Anna Hazare, Arvind Kejriwal, Arundhati Roy, and Kisan Shakti Sangathan, Kisan Mazdoor Shakti Sangathan of state of Rajasthan, and so many other NGOs. They were agitating at state levels to pass this kind of law. And due to the pressure of this, the state of Maharashtra, Goa, J&K, and many others, they pass the state law of relating to the right to information. And because of this, the Karnataka in the year 2002, Goa in the year 1977, Rajasthan in the year 2000, Tamil Nadu in the year 2001, Delhi in the year 2001, Maharashtra in the year 2002, Assam in the year 2002, Madhya Pradesh in the year 2003, Jammu and Kashmir in the year 2004, Haryana in the year 2005. They passed their right to information laws. And this was embarrassing situation for the center, that the state, they are providing right to information to their citizens, but center is not. Whereas center in the year 1966 committed at international platform that they will provide this freedom of right to know to their citizens, but could not. So the pressure from international community, United Nations, pressure from the Indian judiciary through different judgments, and the pressure from the public through NGOs and the social reformers. The government of India become bound to pass this law, and they pass the Freedom of Information Act 2002 first time in the year 2002. But you might remember when Anna Hazare, Arvind Kejriwal, Arundhati Roy, they were sitting on hunger strike in Delhi. They rejected this Freedom of Information Act 2002 flatly. They said that this is a very weak law and it will not give the fruitful results for which this law is being implemented. This law basically is applied to provide the transparent, accountable, and effective administration. And in this case, they all said that this act, the Freedom of Information Act 2002, is not going to meet with the objective of this law. And this is a very weak law, and this must be repealed, this must be amended. And because of their agitation, the government of India sent this law to the National Advisory Council to look into the loopholes of this law. And the National Advisory Council, after going through this law, they recommended that this law need lot of amendments to make it more effective and a object achieving law. After the recommendation of the National Advisory Council, this Right to Information Act 2005 was passed after making number of changes, amendments, or this law, Freedom of Information Act 2002, was repealed by the Right to Information Act 2005. This was a long journey for right to information from the day of the day of its implementation. Now, I am showing a picture. Is this visible to you now? Yes, please. Is it visible? Please tell me, is it visible? Am I visible to you? Am I audible? Please answer me. Am I audible to you?
Yes, sir.
Pardon? Am I audible?
Yes, sir, you are audible.
Now, I'm showing you a picture. In this picture, you can see on your right side, SIC, FAA, SPIO, SAPIO. On your left side, the central government department or organization, FAA, CPIO, and CAPIO. This is the entire structure of the RTI, the Right to Information Law in our country, in state as well as in center. Let's start with this structure from the left, your right side, from the state side. Every department in the country are bifurcated into either central government department or the state government department. And every department, according to this law, has a right to information cell. And every cell is having its officer. For example, SAPIO, look at your right side. The last one, SAPIO, it means the State Assistant Public Information Officer. And SPIO means State Public Information Officer. Then FAA means First Appellate Authority. And SIC means State Information Commission. This is the structure of RTI law in the state. And what are the duties, what are the responsibilities of these people? Let's start with. See, SAPIO, the State Assistant Public Information Officer, he has to collect information from table to table and give it to the Public Information Officer so that he can give it to the applicant. Now, this SAPIO is not legally liable for anything. He is just a person who need to collect the information like a helping hand to the Public Information Officer. But here, the civil power lies with the Public Information Officer. State Public Information Officer, he is having the power of a civil court, and this SAPIO is just a helping person who has to help, because Public Information Officer cannot move every day from one pillar to another pillar, one table to another table, one office to another office. So, state government notify in their official letter who will be the State Public Information Officer in which department, who will be the first appellate authority in every department. By name or by designation, they can be notified. Generally, they notify by designation or by name. Now here, this first appellate authority, sorry, this Public Information Officer, he is the person who is liable for providing information to the applicant. All information is given by the State Public Information Officer to the applicant.
Sir, there's probably some technical issue as we are not able to hear you. We can just wind up the session in 5 minutes.
Pardon, please?
So there's some technical issue as we are not able to hear you properly. So we can just wind up the session in 5 minutes.
Am I not audible?
No, sir. Now you're audible.
Hello?
Yes, sir. Now you're audible.
So I was talking about the State Assistant Public Information Officer. And the State Public Information Officer, look at your right side, the state government organization and departments. SAPIO stand for State Assistant Public Information Officer, and SPIO stand for State Public Information Officer, and FAA stand for First Appellate Authority, and SIC stand for State Information Commission. Now, in this entire structure of the state information law, the SAPIO is not an officer. He is just a helping hand to the State Public Information Officer. And the State Public Information Officer is having the powers of a civil court. He can use or exercise this power to ask anybody to bring the record in his or her possession in front of him, so that he can provide this information to the eligible or competent person or the applicant. If the applicant is not satisfied by the information provided by the First Appellate Authority, this Public Information Officer, or this Public Information Officer failed to provide information within the span of 30 days as per law, then in that case, this applicant will be entitled to have entire information free of cost. Otherwise, there are the charges which are fixed by the public information law, that 2 rupees per page for A3 size, or for bigger pages, whatever will be the actual cost. For example, sometimes people ask for revenue pages, which are very big in size. So whatever will be the actual photostat cost of that page will be beared by the applicant. Otherwise, in a general course of action, it will be ₹2 for A3 pages, whatever information will be sought by the applicant. So, applicant file an application to the State Public Information Officer. Before discussing about this structure, I would like to tell you that what is information and who is entitled to this information and who is bound to provide this information. See, information basically is the record which is lying into the official file of the government department. Any kind of circular, memo, email, opinion, advice, press release, circular, order, logbook, contracts, report, paper, samples, model, data material held in electronic forms even, is if it is a part of the official record, then it will be called the information lying into the official record. Then on the other side, who is bound to provide information, or who is the public authority? A public authority is any authority or body or institution of self-government established or constituted by or under the Constitution by any other law made by the Parliament or the state legislature, by notification issued or order made by the central government or the state government. The bodies owned, controlled, or substantially financed by the central or the state government are also public authority. The non-government organization substantially financed by the central government or the state government are also within the category of the public authority. You might have heard, sometime when you file a RTI against any the private organization, for example, private hospitals, then they flatly refuse that we are purely private organization, we cannot provide this information to you. But no, there are three basic conditions. One, either the organization must be established by the state or central law act, that will be the public authority, or the organization institution must be owned and managed by the central or the state government, or the institution or organization must be substantially funded by the central or the state government. In under all such circumstances, that will be the public authority and will be bound to provide information. As I was talking about the example of the private hospitals. Private people, private hospital, when you file RTI to them, then they generally said that we are purely private organization and we are not bound to provide this information to you. But it is not such. For example, the private hospital, they receive the land on concessional basis to build the hospital. They are given concessional land use or CLU, change of land use on concessional basis. They are given electricity on concessional basis. They are given environment clearance on concessional basis. So in that way, they are getting substantial funding from the central and state government. And if they are receiving such things, then they are bound to provide information under right to information law. On the other hand, you might have heard about the growth of private universities in our country. A lot of private universities are there. And generally, the private universities, they refuse to provide information to the applicants. They said that we are purely privately managed organization. But it is not like that. This all private organization or private universities, they are established especially through the state acts. And when any organization is established through the act of the state or the center, then in that case, they are falling within the category of public authority and are bound to provide information to the applicant. So this was about what is information and who is bound to provide information. So any person who or any organization which is falling within the category of public authority are bound to provide information to the applicant. Now, who is entitled to seek information under right to information law? Any person who is the citizen of this country only is entitled to seek information under right to information law. Not a legal person. Because company, corporation, and industries, they are termed or considered as a legal person in the eyes of law, but they are not citizen. So only the citizen of this country are entitled to seek information under right to information law. Now, come to the point, the picture which I'm showing you, that the special public information, the state public information officer, he is bound to provide two types of information, or you can say information are of two types. One, the information which is relating to the life and liberty of the person has to be provided within 48 hours from the time of filing the application. For example, during the time of terrorism, police was arresting people in Punjab, but was not giving any information, practically speaking. Similarly, it happens even in today's world. Sometimes police arrest the people, take him to the police station, but did not tell anything about his whereabouts to the interested party or the family members. Now, under such circumstances, the family member of that person who has been arrested by the police are eligible to file RTI relating to the life and liberty of the person, and the information is to be provided by the applicant, by the public information within 48 hours from the time of filing this application. On the other hand, the general information is to be provided by the state or central public information officer to the applicant within 30 days from the day of filing application. And if this state public information officer or the central public information officer, if they fail to provide information to the applicant within 30 days, or provided wrong information, or provided half true and half false information, then in that case, the applicant will be entitled to receive information free of cost. And within 30 days from the day of providing the misleading information, partial wrong information, or after expiry of 30 days, within the 30 days from that particular date, the applicant can file a appeal to the first appellate authority designated by the state or the central government in their official gazette in a particular department. For example, generally in universities, in every department, for example, in case of Punjab University, which is having more than 80 departments, all the chairpersons of the department are designated as PIO, Public Information Officer. And the registrar of the university will be first appellate authority. Where the applicant is not satisfied with the information provided by the Public Information Officer, under such circumstances, the applicant is having right to file appeal within 30 days to the Public Information Officer, to the first appellate authority. In case of the university, generally registrar. Now, if suppose application is filed to the wrong person, you want to know the information about district Mohali, and you file your application to the district Gurdaspur, because you are living in Gurdaspur, you go there and file this RTI to the Public Information Officer or RTI officer of Education Department in Gurdaspur. Then within 5 days, the information officer, Public Information Officer of Gurdaspur has to see his application, read the application, and send this application to the appropriate person, means the Public Information Officer of the district Mohali. And the same information will be provided by him to the applicant as well, that you file this RTI to wrong person and your desired information is lying within the possession of this and this person. Your application has been sent to him, so you can collect your information from there. This information is to be given by this Public Information Officer to the applicant, and the application will be forwarded by him within 5 days to the appropriate person who is in the possession of the information sought by the applicant. Now, under such circumstances, this limitation period of 30 days will extend up to 35 days. The 5 days casualty period will be extended. Generally, the Public Information Officer is bound to provide information within 30 days from the day of filing the application. But where application is filed to the wrong person, under such circumstances, the limitation period will be extended from 30 to 35 days. And where applicant is not happy with the decision of the first appellate authority again has to decide his appeal within 30 days, which can be extended with reason up to another 15 days, means maximum 45 days. The application is to be decided by, or appeal must be decided by the first appellate authority within 45 days. And in case where the applicant is not satisfied with the order of first appellate authority, then in that case, again, within the period of 90 days, the applicant has to file appeal to the State Information Commission. And the State Information Commission has to decide his appeal within 30 days. And if the applicant is not satisfied with the decision of the State Information Commission, then in that case, they will go to the Central Information Commission, which we called CIC in this picture given. And the CIC again will follow the power or will exercise the power of the civil court and will decide this matter accordingly. This is the structure of right to information in the state organization and state institutions. On your left side, you can see CAPIO. It is the structure of the central government organization and the department. The right to information structure, which is being followed by the state government organization and departments. Here, the CAPIO, Central Assistant Public Information Officer, he is a helping hand to the Central Public Information Officer. He collects the information from here and there, from one table to another table, one department to another department, one place to another place, and give it to the Public Information Officer. And Public Information Officer, he compile the information and give it to the applicant. Now, again, the same thing happened here also. Within 30 days and within 48 hours, according to the nature of information, this Central Public Information Officer has to provide information to the applicant. And if we fail to provide information within stipulated period of a time, then in that case, applicant will be entitled to take or receive the entire information free of cost, where no information is provided, or partial wrong information is provided, or misleading information is provided, or where the applicant is not satisfied with the information provided by the Central Public Information Officer, then in that case, he will be entitled to file appeal to the First Appellate Authority. First Appellate Authority will be designated by the Central Gazette in their official gazette. Who shall be the First Appellate Authority? Generally, by designation in every department, this CPIO and First Appellate Authorities are being designated. And if after the decision of this First Appellate Authority, in any case, the applicant is not satisfied, then in that case, he will be entitled to file appeal to the Central Information Commission.
Sorry to interrupt you, sir, but can we please wind up in a while?
We have to wind up.
Yes, sir.
Okay. In case, when the case from the state or the central government, the organization, when the case will go to the Central Information Commission, the decision of the or if any, the public authority or public information officer is of the view that an order of commission is not in consonance with the provision of the act, then they may approach to the concerned High Court by way of petition. They can challenge the order of this CIC in the concerned High Court. If suppose a person from state of Haryana or state of Punjab, they file appeal to the CIC and they are not satisfied with the decision of CIC, then they can file appeal in the Punjab and Haryana High Court against the order of CIC. Or if a person is from the state of Kerala, then he will go to the Kerala High Court against the order of the CIC. Now, the main thing which generally everybody is facing a problem, that is relating to the writing of application for information. What is the format of writing the application to seek information under this law? See, there is no specific format which is being provided by either by the Act or by the guidelines or rules provided under this law. There is no single format or specific format is provided. So generally, we follow the application as we have been writing the school leave, sick leave application in school to the principal, subject, and whatever you want to say, that your sincere opinion and your regards, whatever it is. Here, the application is addressed to the public information officer. Generally, people do not differentiate between the state public information officer and central public information. They practically write public information officer, and practically that is acceptable. But legally, if you are filing application to the central government department, then it should be central public information officer. Or if you are filing application to the state public information officer, then in that case it should be state public information officer. Thereafter, the address of the CPIO or SPIO or the department, then right subject. In subject, you have mentioned seeking information under Right to Information Act 2005. Thereafter,
Sir, you have lost your audio again. We cannot hear you.
pardon?
So we
Hello?
could not hear you. So we could not hear you, but now you're audible.
Okay. Now, what I was talking. Yes, what I was talking last. If you want to file RTI application in the central government department, then you have to address your application to the central public information officer. Or if you are filing this RTI application to the state government organization, then you have to address your application to the state public information officer. Then the address of the state public or central public information officer, then right subject. In subject, you have to mention seeking information under Right to Information Act 2005. Full stop. Then on your left, respected madam and sir, then kindly provide me the following information, the copies of following, certified copies of the following information. Then first one, start writing your information, whatever you are seeking. You have to see, remember, while asking or while writing the information, don't write any information in the form of what and why, means in a question format. Because the public information officer is not bound to do research on behalf of you. Because in official record, generally, what and why answers are not recorded. For example, sometime a JBT teacher is transferred from district Mohali to Gurdaspur or Amritsar. He is annoyed with the decision of the government. He wants to file RTI. He has two options. He can write a question that first, why I have been transferred from Mohali to Amritsar. And this answer will not be given by the public information officer. He has to write that kindly provide me certified copy of the transfer policy of the government of Punjab. And after receiving that certified copy, he has to read it and find out where is his case falling, where is the loophole. And accordingly, he can challenge after that, that his case, his status is not falling in any other law provision of this policy. So my transfer may please be cancelled. This is how they have to write. Means don't write any information or seek information in the question form, because they will not answer you. After writing all the informations, whatever you are seeking, or it should not go beyond 500 words. And every application, you have to pay ₹10 for one application. Maximum word will be 500 of your application. Beyond that, they will not entertain your application. And in the end, you have to certify two things in your application: that I am a bona fide citizen of this country, of India. Secondly, the required fee for this application has been paid by postal order, check, draft, or any other mode which is acceptable by the concerned department. Thereafter, you have to write your name, regards, your name, your address where you want that this information should reach, date, and then you can post it. Now, maximum people practically face the problem while writing their name. They feel agitated. If suppose you want to seek information against your boss, your officer, you cannot dare to write a RTI application with your name. You will find out here and there somebody who can write on your behalf. But no need to find out anybody. You, instead of writing your name, you can put XYZ. You can write X. That will be sufficient. But the address where this information should reach to you must be correct. And if you want to hide yourself even from the address, then in the post office department, post office, you can go and purchase a post box, and you can give the address of this post box, so that your complete information about the name of applicant, identity of applicant, address of applicant will be hid. Now, no public information officer can ask you to provide any reason for this information. It is up to you. You may or may not, but they cannot ask you to provide the reason of your information, seeking information. In case of the violation made by any public authority, public information officer, if he failed to provide information well in time intentionally, or if he provide wrong information intentionally, or if he provide partial right or partial wrong information intentionally, and if this fact is proven before the senior competent authority, then in that case, he can be penalized under section 20 of this RTI law, and ₹50 per day will be the fine which will be imposed on him till the time or date of providing information to the applicant. And this ₹250 can extend up to 25,000 rupees, but not more than that. And this amount will be paid by the public information officer from his pocket, not from the pocket of the government. And that's why the public information officers are under pressure to provide this information to the applicant, so that they should not be victimized or penalized in monetary sense. In addition to this monetary loss, if the first appellate authority or state commission or the central commission are satisfied that the public information officer was intentionally not interested to provide information to the applicant, they can issue a warning to the department or send a letter to the department concerned that appropriate action must be taken against this public information officer. And that letter does not mean the department will take and will forget it. The department has to take action against the person, and that action is to be informed to the that concerned senior public authority, so that the other should not do it in future. There are so many things to be discussed now, like who are what are the information which cannot be provided under section 8 and section 9 and section 24 of this public the right to information law. These are the three sections which are dealing with the specific information which cannot be provided under right to information law. So I think time is already short, and I have taken more time as per the instruction by the moderator. So I would like to wind up this talk discussion, my lecture now. If you have any question, any query, any doubt about this RTI law, you may please ask me. Yes, any question, please?
We're open for questions, so if any student has any question, they can raise their hands.
Yes, please. If you have any question, any doubt, you may please ask to me.
Yes, Nalakshi, you can unmute yourself and ask the question.
Good morning, sir. Am I audible?
Your voice is not clear. Please speak loudly.
Is it fine now?
Yeah, you're audible.
Okay, so my question is, can there be a difference between a right to privacy and a right to information? Like, which one of them is more valued? Like, if the war is going on and I wanted to know what defense equipment are purchased using my tax money.
See, right to privacy and right to information are two different, rights. Right to privacy is a fundamental right, and the right to information is a general law through statute provided to us. So always the right to privacy will prevail over the right to information. But there are so many exemptions which I was interested to talk, but because of lack of time could not. Under section 8, subclause J and subclause G and J, it is prohibited that the information relating to the third party that cannot be supplied. That can be supplied, but where there is a threat to the life and liberty of the person, that information cannot be supplied to applicant. Is this clear?
Yes, thank you so much, sir. Thank you.
Okay.
Thank you so much, sir, for today's session. Now I would like to call upon Dr. Komal Krishnan Mehta. Sir has been imparting education at Guru Nanak Dev University Regional Campus, Jalandhar. He has numerous publications to his name, and his expertise lies in taxation law, constitutional law, and right to information law.
Good afternoon to all of you. Am I audible?
Yes, sir, you're audible.
First of all, I would like to congratulate to the whole team of the University Institute of the Legal Study, Chandigarh University, Mohali, for organizing the National Training Program on the Right to Information in collaboration with the Punjab State Information Commission. So today I will, and thanks for the introduction by moderator. Thank you so much. First of all, my topic for today's discussion is function and responsibility of the public information officer under the right.
Excuse me, sir. Sorry to interrupt, but there's some issue with your mic. Your voice is distorted.
Wait for a minute. Now I am audible.
Yes, sir, you're audible.
Okay. Now, as far as my topic is concerned, the functions and responsibility of the Public Information Officer under the Right to Information Act 2005. Before start with the function and responsibility of the Public Information Officer under the Right to Information Act, firstly, I will like to introduce the basic structure of the right to information, how that come into the existence. Next slide, please. So, democracy rests on the government, good governance, founded on the three basic principles: transparency, openness, and accountability. It is the best form of the government which is based on the principle, as the famous quote by the Abraham Lincoln, the government of the people, by the people, and for the people. Why this statement will be a beneficial in this context? Because it serves three purposes. First is the evaluation of the government by the citizens, because we are the person who are appointing the government by the representatives. And after the working by the government, we have to evaluate whether they are on a, whether they have provided the particularly part of the working or not. Secondly, their participation in the decision making. If any law which will be beneficial for the citizen, that should be the public opinion, that should have a create a public opinion, whether they want that particular law or not. And third, it casts a duty on the electoral to keep an eye on the deeds of the representatives, whether the representatives are doing the proper functioning of the department or not, whether they are fulfilling the working areas or not. That's why we are based on the democracy, which on the good governance, the three principles should be there. And that basis, the act should be incorporated. Next slide. So democratic form of government is administered through the people's participation, and such government is presumed to work for the excellence and for betterment of the common man. And we can say that the true democracy cannot exist unless the citizen have the right in the affairs of the policy making of the country. It means the participation of the people should be there in the working of the government. The right to participate in the affair of the country is meaningless unless the citizens are well informed on all sides of the issues in respect of which they are called upon to express their views. It means under the RTI ambit, that's why under section 3 of the RTI says that only the citizens are the beneficiary for the act. It means only the citizen have the right to get the information under the RTI Act, and no other person is entitled. No one is entitled other than the citizen. So this act is the codification of the citizen's fundamental right to liberty and freedom of speech and expression. The information is the power for citizen in the democratic country. It means if the person who is the citizen of country is not having the proper information about the working of the government of India, then it will be say that the person is not participating into the working of the government. Next slide. So in this context, Justice T.N. Bhagwati advised in the S.P. Gupta versus Union of India. This is a very famous case, judges transfer case. This is known as the judges transfer case. AR 1982, Supreme Court 149. The open government is the new democratic culture of society towards which every liberal democracy is moving. But it means every country is moving towards the transparency, openness, and accountability of the government. And our country should not be the exception. Because this judgment is passed in the year 1982, and even though the RTI Act is, so This is the advice or the observation of the Justice P.N. Bagchi in the year 1982 that there should be the incorporation of the Information Act. There should be the incorporation of the Right to Information Act to the citizens. That's why they advise in this particular judgment. Next, please. Now come to the Constitution. What is the preamble of the Constitution provides? The preamble of the Constitution also shows that in democracy, it is the people who are supreme. It means as per the quotation of the Abraham Lincoln, government of the people, for the people, and by the people. The true democracy is governed by the 5 words enshrined in the beginning of the preamble of the Constitution of India. That is, we the people of India. That is the 5 words which shows the responsibility over to the citizen toward the working of the government. So we the people of India. And ending with the 5 again words, give to ourselves this Constitution. We are providing this Constitution for the betterment of the mankind. And broadly speaking, the people of the India are largely living in the darkened side of the governance of the country. Because we are not known to the what the working of the government is there. Whether the contract is given to the Adani or Ambani, we are not known and are the often uninformed about the public affairs and are dominated by those who wield power in the executive, legislative, and judicial sphere. So this is the main basis. The Constitution is also provided for the good governance and democracy, which having the basic feature transparency, accountability, and the openness. Then we can say that we are living in a democratic country. Next slide. Now come to the constitutional basis of the right to information. The right to information came into existence in the year 2005. But before that, there is a provision under the Constitution of India. There are certain provisions under the Constitution of India which provide for the freedom of information. Firstly, the Article 19(1) subclause A of the Constitution of India, which guarantees that all citizens in that particular section, that particular right is also available to the citizens only. All citizens shall have the right to freedom of speech and expression. This right is available only to every citizen of India and not available to a person who is not a citizen of India, that is a foreign nation. Okay? Even though there is one important case law in which the director of the company filed a application for seeking the information, and that application is denied on the ground that director of the company is not the natural person. If the director filed the application by his own name, then that can be entertained. But whenever he filed his capacity as a director, then that cannot be entertained. It's the only living person who is the citizen of the India are entitled for the remedy. So the freedom of speech and expression has been held to be the basic and indivisible for a democratic policy. And the expression has been held to be included in the right to acquire information, disseminate the same. It means the right to know, receive, and impart has been recognized under the right to freedom of speech and expression. Firstly, the person has to get the information. Okay? And it means the right will be exercised. The right will be exercised and getting the information. And after receiving the information, that information should be passed from person to another person. So the 3 main things are there: right to know, receive the information, and impart the information. In that particular context, Justice V.R. Krishna Iyer has observed that right to express one's thought is meaningless if it is not accompanied by the relaxed right to secure all information on matter of a public concern from the relevant public authority. However, to ensure that there is no harm in inserting the freedom of information on a specific corollary to the Article 19 of the Constitution. That's why the RTA Act enables every citizen of the country to obtain the information as a matter of a right, not as an obligation. It means the right to get the information as per the provision of the Constitution of India under Article 91, that is the matter of a right, and that is not as a matter of a obligation. It means the person can seek information as a matter of a right. Next slide. Now question rises, if the constitutional provisions are there under the right to under the Constitution of India, under Article 19 subclause 1A of the Constitution of India, why we need a separate legislation? Next slide, please. Why we need a separate enactment in spite of the constitutional provision? Where the right is available under Article 19(1), which is a fundamental right, then what is the requirement for enacting the Right to Information Act 2005? The right to access the information held by the public body is a fundamental human right of the every citizen, protected under the Article 19(1)(a) of the Constitution of India. But then the question arises, why we need a separate law for the freedom of information when there is a constitutional provision is available? In spite of the constitutional provision which granted fundamental rights, there are certain reasons to do so. Like, first, we have not able to create a culture and climate where the value of the freedom, right, and democratic way of life are respected. One of the purpose of making law like the right to information, which is primarily a human right, is to help to create this culture. And secondly, the provision of the Part 3 Act not only providing the fundamental rights, these are just the enabling clause authorizing the Parliament to enact law for creating the provision for interpretation of the various fundamental rights enshrined in the Part 3 of the Constitution of India. We need comprehensive legislation on each and every right granted in Article Part 3 of the Constitution of India. That's why the right to information must be granted by the strong legislation, and the process of the law making itself must be participated. It means that even though the fundamental right is there, but we need a separate legislation because the mechanism is not provided under Article 19, subclause 1A, how to get information, to whom we contact for getting the information. If that information is not received from that person, to whom we complain against that person. That's the reason we need a comprehensive legislation where the hierarchy, where the mechanism should be there for receiving the information and the if and but of the information. If the information is not received, what to do next? If again on the next step, if the information is not received, then what to do next? The proper hierarchy, the proper mechanism should be provided. That's why the fundamental rights are there under Article 19(1)(a), but the mechanism is not there. That's why the legislation has prepared a comprehensive legislation in the form of the Right to Information Act 2005. Next, now the main objectives of the Right to Information Act, as that particular part is already covered by the learned speaker of the morning session. But I briefly mention the few main objectives of the Right to Information Act. The main objective of the Right to Information Act to bring the transparency and accountability and openness of the government. The working of the every public authority. Those who are having the public authority, they must provide the information on a public domain, suo motu, as per the provision of the Right to Information Act 2005. The transparency should be there. Every act, every working of the public authority should be accountable, should be transparent, and should be open to the citizen of the India. Second, the right of any citizen of India to request access to information. It means the person should have the right to get information from the public domain, and that corresponding duty on the, there is a vicious circle of the right and duty of the one or another person. Now, where the right of the citizen is there, there is a responsibility or the corresponding duty of the government to meet the request, to provide the information. It means the responsibility of the government to meet out the request letter of the applicant and provide that information. And the duty of the government to proactively make available the key information to the all. It means the responsibility under the Right to Information Act is also imposed to provide the suo moto information on the public domain onto the website of the department. Every department show their data on the website with all the aspects of the working. The funding or any kind of the funding is received by the government, the department, that should be on the portal. To whom that disbursement of the fund is there, the availability of the data will be there. To curtail, next is to curtail the corruption and to hold government and their instrumentalities accountable to the government. The major functioning of the RTI is to, the one of the main feature, one of the main objective is to the curtail the corruption, to minimize the corruption at a government level. Whenever we want to take information from the government department, there is a loopholes are there. We have to give the bribe. For example, if I want to take the Jamabandi of my house, of a agriculture land, and I need for that Jamabandi for the loan purpose, I have to spend the money for the in the government department to take the Jamabandi of my property. So this is the particularly hierarchy which is actually working. But if I take that information through the RTI, after making the application to that department, I want that information will be provided to me. That's why there is also the Right to Services Act was introduced in Punjab. Next, that to ensure the informed citizenry and transparency. Whenever the information is not provided to the government, it's not provided by the government to the citizen should not be informed citizen. It means to analyze that we are in a democratic state of the government, the citizen should be known about the working of the government. It means every citizen should be known about the working of the government only when the information should be reached to the concerned citizen. So to ensure less expensive and time-bound information, this is the most important aspect under the Right to Information Act. That could be the procedure, the mechanism which is provided to the citizens for getting the information from the public domain. That should be very less expensive, and the information should be within the time bound. The information should be get by the applicant on a time bound. That is, the 30 days information should be reached to the applicant by the public authority. So coming to the next phase, next slide, the few important definitions under the Right to Information Act are there to analyze the functions and the responsibility of the public information officer. There are the few. The first is the Section 2A of the Right to Information Act deal with the appropriate government. An appropriate government means the relation to the public authority, which is established, constituted, owned, controlled, or substantially financed by the funding provided directly or indirectly. It means directly or indirectly, both are covered by the central government, union territory administration, or by the state government. So these are stated to be the appropriate government. And come to the next important definition, that is the competent authority. Who is competent authority under the Right to Information Act? Section 2E of the Right to Information Act provides the definition of the competent authority, which means the speaker in the case of the House of People or the Legislative Assembly of the state or the union territory having such assembly, and the chairman in the case of the Council of State or the Legislative Council of State, and the Chief Justice of India in the case of the Supreme Court and Chief Justice of High Court of every in the case of the every High Court, and the President or the Governor, as the case may be in the case of their authorities established or constitution by or under the Constitution. And last, the administrators appointed under Article 239 of the Constitution. These are stated to be the competent authorities under the Right to Information Act. Now, coming to the next definition, next slide, that is the Section 2F, which defines the information. This is the very best part of the Right to Information Act, that it provides the definition of the information, even though they are providing the definition of the information, right to information also. Section 2F deal with the information and the Section 2J deal with the right to information. There are certain acts in which the name is also not reflected, as that is not defined. That is the very important aspect, that the right to information provides the both the definition. Information is also defined under the act and the right to information is also defined under the right to information. So the term the information means knowledge communicated or received concerning a particular fact or circumstance or knowledge gained through the communication, research, data, etc. As per the Oxford Dictionary, the information means the fact or knowledge provided or learned as a result of the research or study. The information means any material in any form, including the record, document, memo, email, opinions, advice, press release, orders, logbooks, contracts, reports, paper, sample paper, but on the public domain. That is, it may be in any form, that may be in electronic form or in a hard form. And there is a very important judgment quoted that Jahangir B. Gai, Mumbai versus Bureau of Secondary Education, Department of Secondary and Higher Education, Ministry of HRDC, New Delhi. The decision is on the 21st July 2006. Under this particular judgment, the Commission has held that the definition of the term information under Section 2F of the Right to Information Act includes information relating to any private body which can be assessed by the public authority under any other law for the time being in force is also provided. It means that if the private body is having that information, we are only entitled to get the information from the public authority only. But if the public authority is getting the information from the private body as per the norms fixed by the government, then we are also entitled to get the information from the public authority for the information of the private body. Okay? That's why the domain is also extended with regard to the private body, but only with the subject to that if that is assessed by the public authority. Not in any case, not in every case. So next definition, which is very relevant for our topic, is there. That is the function and responsibility of the public information officer. The public information officer is appointed by the public authority. Okay? So text section 2H means the public authority. The public authority means any authority or body or institution of the self-government established or constituted. By what means? There are the 5 things are there which constituted or which established. First is by any other laws made by the parliament, and by any other laws made by the constitution, by any other laws made by the state legislature, by notification issued or orders made by the appropriate government, and it also public authority includes any body owned, controlled or substantially financed, any non-governmental organizations substantially financed directly or indirectly by the fund provided by the appropriate government. To analyze all the 5 workings, we have already given in the next slide what comes under the authorities established or constitution under the Constitution of India. For example, what can be covered under that first part of the public definition of the public authority under Section 2H of the Right to Information Act. For example, the Vice President, the Prime Minister, other ministers in the Union Cabinet, the judges of the Supreme Court, judges of the High Court, Union Public Service Commission, Election Commission, Chief Minister of the State, other ministers, the State Public Service Commission, Controller Auditor General of India, the Attorney General of India, tribunals, commissions, and more institutions which are constituted by the Constitution of India. And there are the few examples, the establishment and the constitution by any other laws made by the parliament, that is the RBI, Reserve Bank of India, nationalized banks, University Grant Commission UGC, the Central Universities, Security Exchange Boards of India, Banking Service Commission, Telecom Regulatory Authorities Act of India, the Bar Council of India, to whom we are getting the approval for running the law courses, the Medical Council of India, the International Airport Authority, and such other institutions established by the Parliament. And there are a few examples in the next slide by any other laws made by the state legislature. For example, the state universities, like the over Guru Nanak Dev University, Punjab University, State Housing Board, State Electric Board, Municipal Corporations, Improvement Trust, Developing Authorities, State Government Companies, and such other institutions which are established by the state legislature. And in the fourth, by the notification issued or order made by the appropriate government. The appropriate government, which is already defined in section 2A of the RTI. For example, the Central Information Commission, which is the Information Commission under the RTI Act, notified issued by the central government. The controller of the certifying authority notified by the central government under the Information Technology Act 2000 and many more. And lastly, any public authority includes any body on NGO. For example, Central Cooperative Bank, State Cooperative Bank, Export Promotion Councils, aided colleges and aided schools. In that particular sphere of the definition of Section 2 Act of the Right to Information Act, which deal with the public authority, the term public authority is wider than the definition of the competent authority. And thus the public authority includes competent authorities, whereas the competent authority may not include into the public authority. Vice versa is not available. It means the public authority, the definition is more wider as compared to the competent authority, even though the term public authority is more wider as compared to the definition of the state under Article 12 of the Constitution of India. Sometimes the authority may not be covered under the Article 12 of the Constitution of India, but that can be covered under the definition of the public authority under Section 2 Act of the Constitution of India. So next slide, that is the Section 2J, Right to Information. I have already told you yet, the RTI is also providing the definition of the information and the right to information also. So right to information means the accessible under this act, which is held by or under the control of the public authority and include the right to inspection of the work, documents, records, taking notes, extract certified copies of the documents or records, taking certified samples of the material, obtaining information in the form of the disk, CD, floppy, tape, video recording. So many things are covered under the right to information. And the last definition, which is very important, that is the third party. The third party means the person other than the citizen who is making the application for getting the information. But it includes the public authority. Where the PIO, Public Information Officer, intends to disclose any information or record or part thereof which is related to or has been supplied by the third party and has been treated as a confidential by that third party, the concerned PIO, Public Information Officer, is bound to give written notice to such third party within 5 working days on the receipt of the request, intimating that he intended to disclose the information or record or part thereof, and invites the third party to make the submission in writing within the 10 working days on the receipt of that such notice from the PIO. On the receipt of the PIO, representation of the third party, then the PIO shall decide the point whether to disclose the information or not to disclose. If he makes the opinion that the information should be disclosed for the public opinion, for the public safety, and he disclosed that information, the right of the third party is violated by the Public Information Officer. But in that purview, the third party is entitled to prefer an appeal under Section 19 of the RTI Act and the second appeal to the Central Information Commission, as per the provision of Section 19 of the Constitution of 19 of the Right to Information. Now, coming to the main part of the Public Information Office, who are the Public Information Officers? We have already discussed about the various definition and the responsibility fixed under the Right to Information Act. Now we came into the conclusion of who will be the act as a Public Information Officer. The Public Information Officers are the officer designated by the public authority. It means the definition of the Section 2 Act is the authorization for designating the person responsibility to the PIO, who will be act as a PIO in the department. The public information officers are the officers designated by the public authorities in all administrative units or the office to provide information to the citizens requesting for the information under the Act. It means that should be the government department, and the government department, which is the public authorities again, they will designate the particular officers the responsibility as an PIO. So any officer whose assistance has been sought by the PIO for the proper discharge of his duty, then shall render all the assistance, and for the purpose of the conservation of the provision of this Act, such officer shall also be treated as a PIO. It means if the assistance is taken from the PIO by the another person who is holding that information, and the PIO is seeking that information from the person holding that information, that holder of the information is also treated to be the PIO for the purpose of the definition of the public information. Now, what are the responsibilities, functions, and duties of the public information? There are the few responsibilities, functions, and duties are fixed under the RTA Act, which are to be performed by the public information officer. The first, that duty is to render reasonable assistance to the person making the request orally to reduce the same in writing. For example, if a person came to the public authority department, came to the department with the government department, and there is a PIO who is authorized to receive the application, but the person who comes to lodge an RTA application is illiterate person, or he is not having the knowledge about how to write the application. In that particular part, the public information officer is duty bound to provide the assistance to write down the application. It means if he is orally dictated that application, that has to be reduced into writing by the PIO. It is the duty or under the RTA Act. Any PIO may seek the assistance of any other officer for the proper discharge of the duty. We have already discussed into the who is the officer. If any PIO will seek the assistance of the another person, that will also treat it to be the PIO. And the responsibility, whenever the RTA application is received by the PIO, that has to be replied within the 30 days from the date of the receipt of the request, either provided the information or either reject the information. That rejection of the information should be within the specific provision of the section 8 and 9 of the exemption clauses under the Right to Information Act. And moreover, only quoting the section to be that information is exempted under section 8 or 9, that is not the perform the duty. That has to be give the reasons. The reason should be a speaking order of the PIO by on what ground that will on the tip of the request relating to the life and liberty of a person is connected. It means if any RTA application is received by the PIO which is closely connected with the life and liberty of the person, then that reply should be made by the PIO within the 48 hours from the date of the receipt. And the PIO, if that particular application which is received by the PIO and that information is not contained by that PIO, and that will be available with the another PIO, then that PIO has the responsibility to transfer that application to the another PIO, and 5 days will be used for that process. So PIO shall transfer within 5 days that request to the other PIO and inform the applicant immediately, because that is a duty bound process. We have to reply the information within the 30 days from the date of the receipt of the application, and the information is not lying with us. That information is lying with the another officer. Now, in that case, the intimation will be given to the requester applicant. This the information is lying with the another officer, and we are transferred that application. Either that PIO will reply you, or either that PIO will reply to us, and we will intimate to you. So another is where the request has been rejected by the PIO, shall communicate the three main features. If the PIO, after receiving the information, rejected the application, that will be barred by the provision of the section 8 or 9, that information is exempted under the RTI Act. Now he has to give the three things. First, the reason for rejection. On what ground, what are the reasons for the rejection of the information sought by the applicant? The second, the period within which an appeal against such a rejection may be preferred. The time period has to be mentioned that you are authorized to make a first appeal to the first appellate authority within 30 days. That should be mentioned. And the particular of the appellant authority. Who is the appellant authority? That should also mention into the your reply. If these particulars are missing into the reply of in the case of the rejection of the application, that will be treated to be the violation of the provision of the RTI Act. That will be the refusal of the information is also treated. So next, the order of the PAO must be speaking one as to how to came into the conclusion that an exemption is applicable in a case. So merely quoting of the section or the provision or the clause is not enough. So in the case of the Raghunath Lakshman versus State of Maharashtra, AR 1986, Supreme Court 1070, the Supreme Court held that whenever the PIO will decline the application, will reject the application, he will pass the speaking order. Speaking order meaning the reason should be mentioned. What is the purpose of mentioning the reason? That the next appellate authority will came in to know that on what ground the information will be denied by the PIO. If that will be under the ambit of the RTI, then that will be the valid ground. If that reason is not under the ambit of the RTI Act, then that is the violation of the provision of the RTI Act, and the action can be taken against the PIO. So next, if the information sought has been supplied by a third party or is treated as confidential, as we have already discussed that particular point in the third party information, the time will be consumed if the PIO has made a mind that after the opinion is taken from the third party, the information should not be disclosed to the applicant. But after receiving the information from the third party, the PIO has made his mind that the information should be disclosed for the public opinion safety, and he disclosed that information and also intimated to the PIO. Then the PIO shall give a written notice to the third party within 5 days from the receipt of the request and taking the representation into consideration. And if that is a violation of the right of the third party, then the right will be protected after giving the right to appeal under section 19 of the RTI Act to the third party. We can prefer a first appeal, and even we can also prefer a second appeal if the first appeal is not satisfied to the third party. The third party must be given a presentation before the PIO within the 10 days from the date of the receipt of such notice. And there is a very important duty lying on to the public information officers to maintain all its records. And what comes under the maintenance of all its records, it means he has to maintain the register for the receipt of the application under the RTI Act, whether that application includes the fees as prescribed by the Act or not, in what mode the fees will be transmitted by the applicant. The record will be there. He has to deposit the fees into the government account. And moreover, what are the graphic system? How many applications are received? What do with these applications? Whether these are rejected on what ground? Whether they are applied? Whether they are applied that particular information properly or improperly? Or moreover, the maintenance of record by the public information is not with the current date. That will be of a 20 years information can be seek under the RTI. This is the very broader sphere of the RTI Act, that the information seeker can seek the information under the RTI Act for the information of the 20 years from the date of making the application. Because I requested for the application today. From today, 20 years ago, the information can be seen under the RTI. So on the ground that is the public information says that I am not holding of that information, that will not be straightforwardly denied on the ground that I am not the holding of the information. So another responsibility as per the provision of the RTA Act is also the suo motu or the proactive disclosure of the information. There is a responsibility fixed on the very first day of the enactment of the RTA Act. Every public authority should provide the information on a public domain within 120 days from the date of the next. That's why the RTA Act is enacted on 15th June 2005, but it was enforced on 12th October 2005. That is the period gap between the 2 days is the 120 days. It means here the responsibility is fixed by the enactment of the RTA Act. Every public authority should provided that information on their public domain onto the website, onto the department by putting the holding into the department. That information should be provided. So next, the PIO has to furnish the information as available. He is not supposed to. It means here is the information. If the RTA application is received by the PIO and that information is not available, suppose if a researcher made a RTA application to the concerned department for their research purpose, and that information is not prepared by the department for the criteria which is fixed by the RTA applicant. So in that case, the PIO is not supposed to collect or compile the information as per the demand of the requester. He cannot create the fresh information. He can only provide the information which is available with the department. So where information available cannot contain any information which is exempted from disclosure. Now, the very important rule of the doctrine of variability is also applicable in the case of the Right to Information Act also. If the information is seeked by the requester on the ground that the information should be provided, and the PIO, after dealing with that application, concluded that the half of the information is exempted as per the provision of the RTA Act, but half of the information is not exempted. So in that case, if the information will be properly variable up to the exempted one and non-exempted one, we will separate that information and provided that non-exempted information to the applicant and intimated the reason for the non-supply of the another information which is exempted. So where there is no variability is there, the information cannot be severe, then the information will be denied with the specific reason as per the seeking order. But if that information is variable, the doctrine of variability should be applicable. That is mentioned under section 10 of the RTA Act is also available. To intimate the applicant to remit the fees where the fees is not received with the applicant. Sometimes the applicant made an application without the fees. So he has to intimate to the applicant that the fees should be included. Sometimes the application will be received by the PIO enclosing the 10 rupee note on the application. The RTI application is received by the PIO, and there is a application, and along with the 10 rupees fees, instead of the 10 rupees fees in the form of the postal order or the demand draft or the check or the electronic payment, they enclose the 10 rupees note. That is not admissible under the RTA Act. So in that case, the intimation has to be given to the concerned applicant that fee should be provided in the specific format. So it is the duty of the PIO to provide the information within the stipulated time period. Failure to do so is deemed to be refusal. It means the time frame which is fixed by the RTA Act, and that time frame has to be properly adhered by the public information officer while dealing with that application. If the public information officer failed to do that, so it is deemed to be the refusal. And on the ground of the refusal, the certain penalties can be imposed for the non-compliance. That is the next part. Next slide, please. It means if the public information officer deliberately, what are the responsibilities fixed on to the public information officer? That is deliberately, willfully, or knowingly. The three things are covered. Deliberately, willfully, and knowingly refuses to perform the duties under the Act or knowingly violate the statutory provisions of the RTA Act, the penalty in terms of the cash rupees 250 rupees per day, maximum to 25,000 can be imposed to the public information officer. It means if the refusal by the public information officer deliberately, willfully, knowingly or knowingly violates the provision of the act, the penalty can be imposed with regard to 2,250 rupees per day and maximum to 25,000 rupees. That penalty can be imposed by the Chief Information Commissioner or the Information Commissioner at the central or the state level have the power to impose the penalty. But there is a one drawback mentioned into the act that with the PIO who is the holder of the first level information, and after that if the person is not satisfied with that information can file a appeal to the first appellate authority. If first appellate authority is also not provided that information seeker, then that particular penalty cannot be imposed to the first appellate court. That penalty can be imposed only to the public information office. And there is a very important judgment quoted here that is the Devinder Singh versus State of Punjab. The Honorable Justice Surya Kant in this particular case mentioned that the authority, the judiciary has the power to provide for the disciplinary action against the PIO also. If there is a violation of the provision of the act is there, then the penalty, along with the penalty, the disciplinary proceeding can be initiated, but that disciplinary proceeding can be initiated at a departmental level, not at a judicial level. So in the next level, there is a time limit for the disposing of the application is also mentioned. There is a hierarchy. Wait for a minute.
My voice is audible?
Yes, sir, you're audible.
So this is the time limitation for disposing the application provided under Section 7 of the RTA Act is there. Whenever the application is received by the PIO, what the time frame has been given under the RTA Act to the PIO for supplying the information. So in the first instance, the supply of the information in the normal course, if the RTA application is received by the PIO, then that application has to be disposed of. The information should be supplied to the concerned applicant within 30 days from the date of the receipt of the application. But if the information is related to the life and liberty of the person, then that information has to be supplied to the concerned applicant within 48 hours from the date of the receipt. But if the third category, supply of the information, if the application is received through the APIO, the application is sent to the APIO and the APIO will transfer that application to the PIO, then the additional 5 days will be added into that particular application, either in the case of the normal course or either in the case of the life or personal liberty. It means the time period will be a 35 plus 5 days additional. And that should also be intimated to the concerned applicant with regard. You have wrongly quoted the application to the APIO, that is not the holder of the information, that will be transmitted to the concerned PIO. The fourth instance is the supply of the information if the applicant request is received after the transfer from the other public information. That is the reciprocal effect of the third instance. We know that application is received by the concerned PIO. In normal course, that has to be responded within 30 days. And in case of the life and liberty, that has to be responded within 48 hours. But the time period will be 5 days additional used in the case of the transmission from the APIO to the PIO. So there is one important aspect, that is supply of the information by the organization specified in the second schedule. Those who are into the second schedule which fall kar rahe hai, then the information will be, if the information related to the allegation of the human rights, if the RTA application who is seeking the information from the PIO, but that information is relating to the allegation of the human rights, then that information should be provided by the PIO to the concerned applicant within the 45 days from the date of the receipt of the application. And if the information is related to the allegation of the corruption, and the information is received from the public information officer, that should be provided within the stipulated time period, that is the 30 days from the receipt of the application. And the supply of the information, if they related to the third party, we have already discussed into the previous paragraph. We, according to the section 11 of the RTA Act, we deal with that provision. And the supply of the information where the application is asked to pay the additional fees, suppose if the applicant failed to provide the application fees along with the application, or the additional fees is required for providing the information, if he had demanded the bulky information, and that information is having the cost, the intimation is given by the PIO to the concerned applicant that with that needs the additional fees, and you have to pay the additional fees within the period. The time period from the date of making the application by the PIO and for the making the payment by the applicant shall be excluded for the counting of the period of the reply. That may be the 30 days, that may be the 45 days. Okay? That should be excluded. There is a very important aspect I have skipped. If the information is demanded by the person who belong to the below poverty line, it means the applicant is belonging to the below poverty line, then in that case, the information should be provided by the PIO without any cost. The 10 rupees fees, which is fixed by the RTA Act, that should not be also taken from the applicant. That should be provided free of cost to the person belonging to the below poverty line. And how we came to know that the person is belonging to the below poverty line? That certification has to be attached along with the application from the appropriate authority. With that person belong to the below poverty line. That may be the holder of the BPL card. Okay? So in that case, the person has to justify the ground that I belong to the that category. That is the certification given by the appropriate authority. Next slide. This is the hierarchy, or this is the chain is given for the applicant for seeking the information under the RTA Act by the 3 level, because under the RTA Act, there is a 3-tier mechanism is provided. The first tier is the PIO, the second tier is the first appellate authority, and third tier is the Central Information Commissioner. That may be of the state level, that may be of the central level. The 3-tier mechanism is provided, and the application will run in 3 mechanisms by this chart. You will see that the application, firstly, the person had made application, that application has to be replied by the PIO within 30 days. If the reply is received by the applicant and he is satisfied, the application will be disposed. But if the application is received by the APIO and he has to transmit that application to the PIO, the 5 additional days will be used for the date for the transfer application, and that will be reached to the particular PIO. And after that, the particular PIO will reply. If that satisfaction is there, then the application will be disposed. But in case the PIO fail to reply, no reply will be given by the PIO. In that case, the person can prefer an appeal within 30 days to the first appellate authority. And first appellate authority is the person who is the senior officer of the PIO. Senior in rank is the PIO. PIO to upparla jada officer, that will be treated as the first appellate authority. And that 30 days will the time period will be given. Or either he can complain under section 18 of the RTA Act, the complaint directly to the CIC. He has the power to make a direct application also. And after that, if the reply from received, that particular first appellate authority has to dispose of the application within 45 days from the date of the receipt of the first appeal. If he provided the decision and decision is satisfaction to the concerned applicant, then the first appeal will be disposed of. But if he is not satisfied with the reply by the first appellate authority, or the no decision will be second appeal has to be preferred by the applicant to the CIC, Chief Information Commissioner. That may be the state level, that may be the central level, as the case may be. That will be used for the use of the hierarchy for the moving the application from the first level, from the PIO to the first appellate authority, and from the first appellate authority to the second appellate authority. Now the next part, this is the hierarchy of the RTI organization in the next slide. That is from the downward, upward to a downward. Usually we deal that particular application from the downward. That is from the Central Assistant Public Information Officer on the first level, and from the Central Public Information Officer on the second part, first appellate authority, and the Central Information Commission. And this is the hierarchy given on a central level, moreover on the state level. And there is a particularly commission, Central Information Commission, the organization is also provided. There should be a 1 Chief Information Commissioner and 10 additional Information Commissioner. That quantum of the 10 should not be exceeded. That may be the less in number from the 10, but in any case, that should not be exceed the 10. It means that the maximum number in the commission should be 11. One is the chief and another next 10 is the 10 other information commissioner. So next, there is a slide for the various exemptions from the Right to Information Act 2005 under section 8 and 9 of the RTA Act. There are the first 10 exemptions are dealing with under section 8 and 11 exemption is dealing with section 9. What are the exemptions from the disclosure of information? My learned colleagues from the morning session I'll already discussed. I just go through the briefly what are the exemptions. The sovereignty and integrity of the nation. If any information which is sought by the information seeker relating to the sovereignty and integrity of the nation, that will be declined under section 8 of the RTA Act. If any information related to the expressly forbidden by the court of the tribunal, that should be a decline. The breach of the privilege of the parliament or the state legislature, that should be declined. Any information related to the commercial, trade secret or intellectual property. If the person want to be the trade secret of a particular profession, that information can also be declined. Any information which is relating to the fiduciary relationship. I think I'm laudable.
Yes, sir, you're audible.
If any information is relating to the foreign government, any documentation is between the India and the foreign government, that information should not be released with the security purposes. Any information endanger the life and physical safety. Suppose if we want to take the information from the bank that when the cash will be received by the bank and who will be holding that cash. If that information is disclosed by the banker to the information seeker, that may be the endanger to the life and physical safety of the person who is holding the cash and who is carrying that cash. So impede the process of the investigation. Any information seeking from the investigation officer with regard to the investigation process that which impede the process of the investigation, that information can be declined by the officer. Any cabinet papers information, those information relating to the cabinet paper, that can also be declined under the RTA embed. Any personal information can also be declined. But if the personal information is beneficial for the public purpose, for the public domain, that can be released. That will be also come under the section 11 of the third party information. And last is the rejection to the access to the information in the infringement of the copyright, section 9. If any information is dealing with the right to information with regard to the copyright of the somebody else, then that information can also be declined. This is the gist of the exempted organization under the ambit of the RTA Act under section 24, which is part and parcel of the second schedule. 22 organizations are under that particular ambit. These are totally related to the security purposes. For example, Intelligence Bureau is there, Director of the Revenue Intelligence is there, Border Security Forces, Indo-Tibetan Border Policies, Assam Rifles, Shastra Seema Bal, Director General of the Income Tax Investigation. These are already, there are the quantum of 22 organizations which are fixed for the exempted organization. From these organizations, you are not entitled to get the information under the RTA Act. Now the next part, that is the we have already in these slides discussed about the working of the RTA Act in somehow, functioning of the RTA Act through the PIO, but there are certain problems in assessing the information. What the problems are there? No doubt the Parliament has passed the Right to Information Act 2005 with the main objective to bring the transparency, openness, accountability, informed citizenry in the working of the public domain. But generally, the public is still facing the number of problems in assessing the information. That may be the various reasons are there for not getting the information. These are from the both sides. That may be the lacuna from the administrative part. That may be the lacunas or the limitation on the part of the public. What are the problems identified by the researcher in that particular case? What problems are faced in assessing the information? Firstly, on the part of the government organization, that is from the PIO, untrained or no proper training to the PIO. The public authority designated the PIO for providing the information to the citizen of India under the RTA Act, but no training is provided to the PIO how to deal with the application. What kind of the information is demanded by the PIO, by the information seeker, and how to deal with that application. Sometimes the public information officer are appointed from the background who is having no that tendency for providing the information. That is also the lacuna of that particular RTA. Secondly, poorly maintain the official record. No, in a government department, the records are not properly maintained in somehow. We are saying that we suo moto, the public authority put their information into the public domain. They are not providing the information into the public domain. Whenever we go to the website of the government department, we click into the Right to Information Act, the link click karte hain, that there is when after the clicking that there is an error, 404 error is there. There is only thing that the ads are there into the that website. Third, the culture of secrecy prevalent in the government offices, because even the third level, the CIC, Chief Information Commissioner, are the retired bureaucrats, and they are also having the culture of the storing the information. See, they have to be a secret that information, not to the disclosing that information. The fourth is the rude attitude of the officers. They are very rude in dealing with the application. They are not dealing properly manner while dealing the application. We have already lined the responsibility onto the PIO to reduce the application on the case of the illiterate person, but nobody will be there to write down the application on the behalf of the information seeker. So, poor quality of the information providing. We are seeking the information, and the information provided by the PIO will be on the another contest. We are demanding the information in one contest, and they are providing the information in another contest. There is no relevance of the information. What kind of the information is seeked by the information seeker? He is not providing that kind of the information. 6, no strict rules of the suo moto dissemination of the information. I have already quoted that the dissemination of the information suo moto is lying on to the public authority, but they are not providing that information into the public domain. So corruption already peep into the roots of the government department. They will take out the various routes how to tackle the money from the RTA applications. 8, less determinant penalties to the concerned official who failed to provide the information requested. The information, non-providing the information and non-compliance of the provision of the RTA Act by the PIO, the penalty will be 250 rupees per day, maximum to 25,000 rupees. And that is a very nominal amount as compared to the information is related. Or somehow the first appellate authority is not covered under the bit of the section 20, which provided the penalty to the first appellate authority. They are not providing the penalty to the first appellate authority. They are only providing the penalty to the public information officer. So no provision under the RTA Act which provide the penalty to the appellate authority. Lack of the awareness among the public about their rights. Generally, in India, the lots of people are not known to the basic rights of the, which are given by the constitution, which are given by the legislative acts. So due to the lack of the awareness about their rights which are available, they are not having the sufficient resources to get that information through the RTA portal. That may be the ground of the illiteracy. Due to the illiteracy, they are not having the right. That's why we are not covered the poor people, because the information can be reached to the person with the 10 rupees. But the person who is illiterate and he is not having the what is the mechanism to get the information from the RTA Act, what level of the information is there, to whom I contact for the getting the information. So on these ground, the lack of the awareness on the ground of the illiteracy by the person who is seeking the information, the problem is also assessing the information. The person is not able to get the information from the public domain. Whenever he is not able to get the information, he will not able to disseminate the same. So the role will be actively played by in these circumstances by the RTA activists, those who are organized, those who are having the organization, those who are working for the betterment of the citizens. They are providing the help to the person who's demanding the information. So with these words, I concluded my talk on that. Let the people know the facts and the country will be safe. Whenever the people will know about the working of the government and the country will be safe, because there will be no lacunas, no if and buts are there for the question mark onto the government's working. So whenever the people will be known to the facts of the things about the working of the government, the country will be safe and there will be no question mark. That will be the quote of the President Abraham Lincoln. That's over from my side. Any query, any question from your side, that is most welcome.
Students, if there's any questions, you can raise your hand. Okay. Thank you so much, sir, for the session. It was a pleasure to have you with us. Now I would like to request. Okay, we have a question. Student, you can unmute yourself and ask the question.
Good afternoon, sir.
Good afternoon.
Sir, my question to you is like, can a spouse have information of the properties owned by the partner under right to information?
I have already mentioned into the exemption clause, the personal information is barred. Under section 8 of the RTA Act, that will be there is a bar for the personal information. But there is one provision provided for getting the information from the public domain. If you want to get the information from the income tax department with regard to the husband, how much the income is filed by the person into the RTA under the income tax department, that information can be seen. But under that provision, section 11 will be applicable. The third party information. Whenever the application is received by the income tax department to deal with the application regarding the disclosure of the information regarding the income filed by the concerned person. In that case, the income tax department will give the intimation to the concerned third party. Then that will be if the denial. Then in that particular regard, I will give an example that suppose I want to know the income of the Shah Rukh Khan. How much the income is filed by the Shah Rukh Khan in that particular previous year. So this is the information relating to the personal information of the Shah Rukh Khan. But that information which is filed by the Shah Rukh Khan to the income tax department, that is the public domain. I can write application to the income tax officer dealing with the ward of the Shah Rukh Khan. I write down a RT application to the concerned officer, and concerned officer, after receiving that application with regard to the Shah Rukh Khan, he will intimate that to the Shah Rukh Khan to be application received with regard to that they want to know about the income of your. And after the reply received from the Shah Rukh Khan, either he denied provided the information, or either he said that we provide that information. In both the cases, the information received by the PIO Now PIO will think so that be whether I want to release that information or not to release. If he release that information to me and disclose that be how much the income is of the Shah Rukh Khan, and he will give the intimation to the Shah Rukh Khan that I have released the information for the public opinion, for the public safety. So you have a right to make an application under the first appellate authority, appeal kar sakta hai Shah Rukh Khan, and he can also have the right to file an appeal to the first appellate authority and to the CIC. So in that particular purview, you can assess the information of the personal. Otherwise, the personal information is totally barred as per the provision of the Section 8 of the RTA Act. Hope so. My submission will be satisfied to you.
Right, sir. But like in some cases, like we can have an example of a maintenance case. If a wife wants to know like how many properties are owned by the husband, so she cannot get any information regarding that.
No information will be entitled. That information will be entitled from the concerned public authority, not from the public. If I want to know the information about my wife, how I came to know the information from the wife? From the wife only, or to
Right.
the concerned authority. So I can make an application. The provision will be there for the third party information. Otherwise, the personal information will be totally denied.
Right, sir. Thank you,
Any
sir.
other question?
Thank you very much, sir, for this wonderful session. Now I would like to request the pillar of our law department, Dr. Radhika Dev Verma, HOD, BCom LLB and BBA LLB, Chandigarh University, to kindly deliver a vote of thanks.
Good afternoon to all. Honorable distinguished speakers, respected Director, UILS Professor Dr. O.P. Mehta, faculty members, and our dear students. On behalf of the organizing team of UILS, I deem it a great honor and privilege to propose the vote of thanks on the second day of National Training Program on Right to Information, various facets of RTI 2005 in collaboration with Punjab State Information Commission, Punjab. At the outset, I extend my heartfelt thanks to our distinguished experts on RTI, Dr. Shipra Gupta, Department of Laws, Punjab University, Professor Dr. Ajay Ranga from National University, Shimla, and Dr. Komal Krishan Mehta ji from GNDU Jalandhar campus for sparing their valuable time and generously sharing their wonderful insights on RTI. Your participation has actually given depth to the session. Thank you for enriching us. I would also like to express my profound gratitude to our worthy director, Professor Dr. O.P. Mehta, for his exceptional stewardship, support, vision, and continued efforts to hold such significant events relevant for our growth. Thank you, sir, for your dynamic leadership and motivation. A special thanks to our student organizers and Ms. Akshata Negi for moderating the session and for technically supporting today's session flawlessly. Last but not the least, my deep sense of appreciation to our faculty and student participants for their patient listening and participation. Thank you, everyone, and have a good day ahead. Thank you.
Thank you very much. Thank you, Dr. Komal, for sparing your time for us.
Thank you so much, sir.
Thank you. Thank you, Dr. Radhika.
Thank you, sir.
Thank you so much, everyone, for joining us today. You can leave the session.